There we go.
Let you know when I see it.
Okay.
Yep.
All right. Okay, good morning, everybody. Like I said, I'm Eileen Kendall of Kendall Law. I recognize some of the names of the participants, so I'm glad that you're here today. I did this presentation early on when this all started, and so I'm just going to give you some updates. I'm going to give you the caveat that I did the last time, is these are changing frequently. There are a few that are subject to change by meetings that have already taken place, but they haven't issued any new rules. Some of them are on a month-to-month basis on being evaluated on whether they're going to continue. So while this may be current as I am presenting it to you today, it might not be current tomorrow, so don't rely on it beyond that. Just always double check. But this is the information that we have right now on the COVID-19 and the rental market. So today we're going to discuss the state orders, local orders, and what the court system has decided to do. Even if with all these other local orders, the court system has also stepped in. So we have the state order that was initially issued on March 27th, 2020, that has now been revised on May 29th to be extended for an additional 60 days through July 28th. What he has done is given local jurisdictions the authority to continue to impose the limitations on evictions, both in residential and commercial. Basically, if you're unable to work because the tenant was sick or suspected or confirmed case of COVID or caring for a family member that is sick, they're likely going to be protected by the local ordinances. It is a showing of, not a showing, I shouldn't say, because now some of the jurisdictions are just taking the tenant's word and you don't have to provide any evidence of it. But the examples of how you can be protected by the eviction rules is that there's a layoff, a loss of hours or other income, or there is having to care for somebody. Now it's summer, the school issue isn't as much as it was before, or if there's medical bills. So it really has to be related to COVID. So there are that's the state order. The Los Angeles Board of Supervisors has issued some rules that are county-wide. It is currently effective from March 4th to June 30th, and it's going to be renewed on a month-to-month basis. I actually listened into the last call where they talked about this. They had wanted to extend it through August, but luckily the board decided that it was only going to be to June 30th and that each month it would be evaluated. My opinion is that hopefully that this won't go much longer. Things are opening back up. People are going back to work. They should not be afforded any more protections, in my opinion, once you go back to work. Obviously, there might be this transition of a month where I'm just going back to work now. It'll take me a little while to get money, but this isn't going to keep going, hopefully, for very long. The county is both residential and commercial. It's incorporated and unincorporated areas. This is a change from when this rule originally was issued, because before it was only in unincorporated areas. They have now expanded it to even incorporated areas that have not adopted either moratorium, or if an incorporated area has one, then the county's other. So say, let's just go with Torrance. Torrance only has, and this isn't true, but I'm just giving as an example. If Torrance only had residential rules, then the county's commercial rules would come into play. So they really have expanded the county to include, so pretty much every jurisdiction is now going to likely be covered under either their own or the county's. So for under the county, what types? It is for a non-payment of rent, and that includes rent, late charges, or other fees accrued, and it's due to financial impacts related to COVID, which is what I explained earlier. It also prohibits evictions based on the presence of unauthorized occupants, pets, or a nuisance. Now, the way that this code reads is that it is unauthorized occupants, pets, or nuisance due to COVID. So I have a case right now where there's a couple of pit bulls that they brought in without approval. They're not allowed under the lease because there are no pets, although he's now going to go get a certificate saying it's an emotional support dog. If it was brought in before COVID, I'm telling my client to make sure that the notice that they're giving of the breach says that these were brought in prior to COVID and are not COVID related. Because I think what they're trying to cover here is if you have family members that are now living with you and they've brought in a pet because they are, due to COVID, they needed a place to stay, or you're caring for them and the pet is there, I think is what that protection is for. County is also done a rent increase freeze through June 30th, so landlords can't increase the rent. And it also includes no fault evictions unless necessary for health and safety. So when we talk about the court and what they've done is basically you can't file an eviction unless it's health and safety. So yesterday, yes, today's Thursday, Wednesday morning, I went into Inglewood court the second time in a month on the same case, and it was nice to be back in the courtroom. My client has a tenant that back in February threatened another tenant with a gun. He didn't actually have a gun. He said he had a gun in the house. He's going to kill the tenant, and actually described how he was going to dispose of the body. And he's now, peeing over the balcony, lewd conduct, et cetera, et cetera. So my client had given a notice to cure and then filed an eviction. And I went in yesterday on an ex parte basis to ask the court to issue the summons. Because as we'll discuss later, the court is not processing any evictions for any reason whatsoever unless there is something health and safety. To my surprise, the judge did not grant my request. He said that it was a one-off. There's no evidence that she is really in fear of her safety because she didn't call the police or she didn't get a temporary restraining order. My presence in the court yesterday with the judge, I was the only one there. I'm familiar with this judge, and he gave me a lot of information that's going to be really helpful for my clients, and the idea that I have 3 or 4 that want to go in on this exception and try to get the case moving along. And more likely than not, unless there is something seriously at issue that the court or the police have been called or there's a restraining order, I don't see that these judges are going to grant these requests. Nikki, do you want me to take questions as we go?
Whenever you want.
Okay, and I want to make sure, somebody said that they can't hear me. Can everybody else hear me? Usually I don't have a problem with my.
We can hear you.
I usually don't have an issue with my voice because I'm usually loud enough. All right. So in the LA County, the notification requirements are that the renter must notify the owner within 7 days after the rent is due. Their documentation under the county is that the owner just needs to accept self-certification of the renter's inability to pay rent. When we talk about some of the other local jurisdictions, some actually require documentation. In the beginning, I think a lot did. Tenants started to complain, and as we know, the tenants get a lot of rights in this state, so they started to change it. So they can, owner now must just accept a tenant saying, hey, by the way, I can't pay the rent, so I'm not going to pay it. I have a client that's reached out to me just yesterday. When they vetted the tenants, they had lots of money in the bank. They're going on vacation, but they're still wanting some kind of relief, but my client has to accept the self-certification that they can't pay the rent, and we can't ask for any documentation. It is deferred rent. It is not a forgiveness of rent. Your tenants do have to pay. Under the county, the renters will have 12 months following the expiration of the moratorium period. So if June 30th is the last day, that clock starts ticking, and July 1st, they have to pay it within 12 months of that July 1st date. The owner may request and accept partial payments if the renter is able to pay. A lot of the ordinances are in favor of trying to work out some payment plan. The county or the state or the tenant's rights, whomever it is, are really lobbying very hard to actually make the deferred rent not a rental obligation, but making it a commercial debt that would not be able to be collected in an eviction action. What would happen is if this passes, and it has been shot down, I think, twice now, is that the deferred rent would just be a consumer debt that you'd have to take to small claims. You couldn't use it as a basis in the eviction action. For additional information in the county, like I said, it encouraged owners and renters to enter into a payment plan. It does prohibit harassment or intimidation. In the very beginning, you were seeing on the forums that landlords were tracking stimulus payments and getting in touch with the tenant saying you should be getting your stimulus payment, you need to pay the rent, or you're getting unemployment, you need to pay the rent. So they put these in place where they now have monetary penalties for violations. And when we go into the city, it's created a private right of action, and the fines and the damages could be substantial if there's violations. So going to the city of LA, it is both residential and commercial. It is a non-payment of rent, no fault evictions, and evictions again based on nuisance, unauthorized occupants or pets, and prohibits Ellis Act evictions, which is where a property owner wants to take an occupied residential property off of the rental market. Those are not allowed during this time period. Under the city rules, they have 12 months to repay if it's residential, but commercial units only have 3 months to pay it back after the emergency order is lifted. In the city of Los Angeles, owners are required to provide notice to the renters within 30 days of the ordinance, which has already passed, so hopefully all of your clients have given that notice. And each time a landlord gives a notice to terminate, so if you do the moratorium is lifted, you do a 3-day notice to pay or quit, you have to provide the notice to the tenant of their rights under this ordinance, which is the repayment plan at that point. I have two of the same slide. All right, and so the penalties, and that's pretty much, the city's gotten pretty serious about it. They are now saying the city has created a private right of action for tenants to sue landlords for injunction and monetary damages. So what that means is they can bring an affirmative action like they would on like a habitability claim or a breach of a contract claim and say that the landlord has done X, Y, Z in violation. So not only can you get regular monetary damages, which I don't know how they necessarily quantify, but the court can also award penalties of up to $10,000 per violation. And then you can add an extra $5,000 onto that 10 if the tenant is 65 or older or disabled. Once the violation is noticed, the owner has the opportunity to cure. The question I have is, can you please discuss the exception regarding eviction right now, whereby landlord can indeed evict due to renovation? That is not allowed right now. That is what they would term a no-fault eviction. So there is no exception for that right now. It is, unless it's a jurisdiction that doesn't fall in the city of LA or within the county, and it has its own rules, but most of them are all including no fault. I think Long Beach is an exception that it is for a non-payment of rent only. So it doesn't, renovation doesn't matter right now. Right now, there's no way you really can get people out of property, unfortunately. But again, it depends on your jurisdiction. So now I'm just going to kind of go through some of the local cities. The city of Hermosa Beach is residential and commercial. Under Hermosa, the residential must demonstrate an inability to pay rent. Well, what does that really mean? Well, there's really no definition. Can a landlord demand documents? Under demonstrate, I think that they could. In Hermosa, you can't serve a 3-day notice if the tenant within 30 days after the rent due notifies the landlord of the loss of income. So if the rent was due June 1st and they notify you within 30 days of not being able to pay rent, you can't do a 3-day notice. And it says that they have to provide that documentation. Again, these change pretty frequently. In Hermosa, they have to pay within 6 months, and you can't start the eviction within that 6-month period of time. Let me just finish this and I'll go, there's a bunch of questions. Commercial, tenant demonstrates that the business is subject to the orders, that they have been closed to prevent the spread of COVID, and the tenant demonstrates financial impact. This is going to change, obviously, because more and more things are opening up. But if your commercial tenant was a hairdresser, they can't open, then they would be protected by this ordinance. What about the eviction was filed before the COVID-19? Well, the court's still not doing anything. The court is absolutely at a standstill. The writs that I had sent to the sheriff have been sent back. My understanding is starting next week, the sheriff might be back into serving them. So I've sent them back to the sheriff with my fingers crossed that we can now proceed with lockouts. But the court is at a standstill. We'll talk about that at the end because the court's done their own thing, but it doesn't matter. We have tenants not paying since November. He's owing over 10 grand, which is the best way to get him out. Will the court process the case because it's filed before shutdown? Again, no. So what I am telling my clients is that if you have people that have not paid rent prior to COVID, start your case. Your case is going to get a case number, but you're not going to get a summons. And you have to now wait until either, and I'll talk about it again, there's this emergency rule in place to be lifted or for the time to pass. So I have been filing cases for my clients. Some are not even related to non-payment of rent, like the one that I described about the nuisance. I have one that had a resident manager that was terminated and she was supposed to move out and didn't move out. So I brought that case. I have one with, dogs and, police reports that I'm bringing. But if they were supposed to pay, like you said, November, December, January, February, you need to move that case into litigation so that at least you have a case number. Because what will happen is you'll be in front of all the people that are waiting. So you can file, but you're likely not going to see a courtroom until fall or early 2021. If they demand a jury trial, it is possible that it's not going to be until late 2021 until we see a courtroom. But everything is changing. The judge yesterday gave me a lot of information that they are working on the backlog starting, July 1st. They are going to be staggering hearings. Instead of having everybody in the courtroom at the same time, they're going to be 5 at a time at different times of the day. Are single family homes included or exempt? Everything. This isn't like rent control. This isn't like 1482. This is for everything. If it's residential and commercial and your ordinance is like Hermosa is residential and Hermosa, there is no exception. So in Long Beach, it is residential and commercial. It is for non-payment of rent only. So this is the one city that has not gone as far as the other cities. The tenant must, before the expiration of the 3-day notice, notify the owner that they can't pay rent. So this is subject to change due to a meeting that they just had on June 2nd, but they haven't written anything out yet. Long Beach right now is allowing owners and property managers to go ahead and issue 3 days notices on delinquent rent, but they have to include the language in the 3-day notice that of their protections. And Long Beach's statute has very specific language to include. If they're not paying the rent, they have to repay it by November 30th. Like I said, this is subject to further revisions on a meeting that was on June 2nd, but they haven't sent anything else yet. Is there notice to the tenants in the CAR forms? I know that there are some forms in the CAR forms for this, but I don't know if it has anything to do with the moratoriums. Honestly, I haven't been looking at the CAR forms. I have been solely, my information comes from the Apartment Association and the Rent Stabilization Ordinance, and they have certain forms that landlords have to be giving to their tenants that have the specific language. I've been using the statutes themselves. So I'm not sure if there is a CAR form. Okay, I think that I saw some questions. Okay, all right. I already covered all those. Sorry, it's hard to keep track of both. All right, so Inglewood is residential and commercial. It expires June 30th unless it is extended again. It is for non-payment of rent, no fault evictions, stateless act evictions where it's removing rental market, the rental from the home from the rental market or the building from the rental market. In Inglewood, there is no notification requirement for the tenants, but it does mention that the tenant needs to provide documentation. It doesn't say what type or when they are supposed to give it. I think that a lot of tenants' attorneys are telling their clients that they just need to keep it in their back pocket so that when a landlord files an eviction, that they bring it up as an affirmative defense and say, Your Honor, they shouldn't be able to proceed because I had an inability to pay rent, which really isn't very fair to the owners if there's no requirement. I have a couple of clients that have tenants that just aren't communicating as much as we've tried to communicate with them, or they have tried sending letters saying, hey, we understand that this is a difficult time. Please let us know if you can't pay the rent, what the issue is. They're still not communicating. So owners just have to assume that they can't pay the rent and have to abide by these moratoriums. Inglewood does have 6 months to repay after the expiration of the emergency order. And then other cities, Redondo Beach is until the end of the state of emergency. As of May 7th, it is subject to the county rules, which we went over earlier. For Torrance, as of May 19th, it is also subject to the county rules. Santa Monica is through June 30th unless extended. It is residential and commercial. It's a non-payment of rent and no fault evictions. Santa Monica, like the city of LA, the owners must give the tenants a notice of their rights under these moratoriums. Residential and commercial have 12 months to repay. However, they have a non-retail commercial that has to pay within 30 days of the expiration of the order. Santa Monica, like the city of LA, also has a private right of action to sue for penalties and violations. Santa Monica is under the rent stabilization ordinance, so I'm assuming that's why many of them are similar. So now that just I wanted to just do some of the local cities and then the overreaching of the county. So courts, this goes back to one of the questions. Is there something that we can do? Well, no. When I was in the court yesterday, I literally was the only person. The judge has said that they will start opening up the court next week. They are urging people to be on court call. They are trying to do the backlog. What the court has issued is what they call emergency rule number 1. And the emergency rule says that no summons on any case, whether it is commercial or residential, related to non-payment of rent or not, for 90 days after the emergency order is lifted. So for filing cases now, they get a case number, and then we have to sit and wait for 90 days after the governor has issued the order, or released the emergency. The judge yesterday indicated that there is a potential that the emergency rule will be repealed and that we won't have that 90-day period anymore. The judges are, waiting and discussing this very frequently. Rules are coming out on just way that the court is going to run when they open up next week. They're also pushing out if you had a trial already set before this went into place, everything is going to be continued 60 days. If you have not requested a trial and you are at issue, which means all the parties have appeared, and you want to set it for trial, it's going to be a long time. My guess is that the tenants' attorneys are circling like sharks. They're waiting for landlords to start these actions. I am familiar with several of the attorneys. One of them in Long Beach, where I am more frequently, he goes out in the hallway and he announces, that they're allegedly pro bono. I don't believe that that's true, and solicits people that have appeared on their own behalf, and they substitute into the case. I think that they are just waiting for the courts to open up. And what that means for landlords, unfortunately, is they make life hell, pretty much. They do discovery and they demand juries. And if you're going to get a demand for a jury trial, there's no telling at this point when we might see a courtroom. And so it's really the discussion, and it's hard for mom and pop type landlords to really get their mind wrapped around a jury trial in an eviction case can be $11,000, $15,000, $20,000. And right now, you're not looking at having any time in the near future of getting in the courtroom for that trial. So it's really a decision that has to be made on a business level of, okay, do I just pay them $5,000 or $6,000 to get them out now, or do I wait and play it out and spend all of that money on attorney's fees and then take it to trial and then have to go through the process, which might not be until 2021 at some point. So it's really an unfortunate circumstance for your property managers, your owners, and clients that have rental property, because they really have their hands tied right now. I was really surprised yesterday when the judge didn't grant our request. So let's see. Can we serve a 60-day notice to move our tenants due to the safety concerns of the tenants and other street? He's dangerous and tenants are scared to live there. So that goes back to, we can try. It depends on the evidence. After being there yesterday, the judge said that had there been a restraining order requested or taken out because the other tenants were fearful for their life, that he might have ruled another way. If the tenants had called the police and there's a series of police calls and police reports and it's not just a one-time thing or isolated events, then he might have ruled differently. So the exception is there. I've only now been in front of one judge on the exception, but I think that they're all being counseled by the head honcho judges that are telling them how to make these rulings and what to look for. So whether or not we would be able to proceed is just a matter of what the evidence is and if the court feels like it's enough to grant the extension. Manhattan Beach. How about the city of Manhattan Beach? You know what? They are not listed on the apartment association as having any, so they would be falling under the county rules that I listed in the beginning. They don't have anything independent. They're just going to fall under the county. I have a client who's received 30-day notice from a tenant who has not paid since April. Tenant is paying rent as of June, but owes April and May. Does the landlord have the right to make the tenant pay full month of rent if the tenant moves mid-month or only owed a prorated amount? That just isn't really COVID related, is that they would only have to pay the prorated amount. You can't force them to pay the full amount if they're going to move out early, especially if they gave a 30-day notice and that mid-month is ending mid-month. So if they gave notice on May 15th and they're moving out June 15th, then you're going to just be able to accept that prorated rent. And technically, the tenants are still required to pay the rent, even if they move out. Good luck. That's as bluntly as I can say it. Even in regular time evictions, when you have judgments for rent, back due rent and evictions, they're likely never going to be seen again. It's just what it is. If it becomes and they change it to a consumer debt and it's not related to evictions, that's still the same, going to be the same outcome, is you're going to have to proceed collection matters. So if your tenant has that back due rent, it's just going to turn into a collection account. If they're not paying, it's not likely that they have the money or they're hiding it or whatever. And they're going to leave and you're never going to see it. It's the sad truth. Hermosa commercial tenants not paying rent due to COVID. I understand landlord cannot require documentation of inability to pay. Is there a legal way to verify the business did not receive funding grants to cover rent and not pass the funds to the landlord? So I think that that's where a lot of the changes stemmed from, is because landlords were looking to see if they got an SBA loan, whether they got a stimulus check, whether they were receiving some type of benefit. I'm not aware of any legal way to get that information. I'm not aware of a way that you could pester, because that's going to be under the harassment intimidation. Unfortunately, I think these landlords, and I'm a landlord too, I'm a landlord attorney. I have to explain this to people every single day, and it's not a happy topic for a lot of people. A lot of people, this is how they pay their mortgage. This is how they, have to pay for the upkeep, or it's their retirement. It's just really unfortunate that it is what it is. We have to be understanding, as much as it's hard to do, especially if you know that they're probably receiving money and deciding not to pay the rent, and just hope that they come and they come through and pay. I think that if you negotiate a payment plan and get it in writing, and then later they don't pay, whether you can do it in an eviction or in a small claims, you have something in writing where they agreed to make the payment in writing, and you have a stronger case to try to collect it. In the commercial sense, I think you're more likely to see money because they have a business, unless their business really failed because of what's happening. But if it's a business like, hairdressers were out of business for the period of time that they couldn't have contact. But I can guarantee that those businesses are slam-packed busy because of everybody that was dying to get their hair did, and their nails. I don't even want to try to call to get a nail appointment when it opens up, because they're going to be really busy. So they're going to remake the money, and they're more likely to pay. On the residential side, I just don't think that landlords are really going to see much of that money unless they really do have upstanding clients. But I know that a lot of tenants, from what I'm seeing, are just boycotting rent just to boycott rent because they think landlords are horrible. I have a great idea. To pay the tenants to move out, would the landlords have to abide by the rent control ordinance? That depends on where your location is. If you're in a rent stabilization ordinance, then you're going to be governed by those rules. If it's a at-fault eviction, your relocation requirements under rent stabilization ordinance don't come into play. If you're under a rent stabilization ordinance, there are only certain ways that you can evict, and then you have to pay relocation. If you're not in a rent stabilization ordinance location, and you're just being under the 1482 because you're not a single family home, if you have a multi-unit, you're having to pay the 1 month of rent or waiving the 1 month's rent. So you wouldn't be anywhere near that $20,000 mark. So the short and easy answer to that is it depends on where the property is and what is the governing body about what the terms of terminating an employment or terminating a residency is. Lomita, can I file an eviction after June 30th? No rent since March. So I believe Lomita doesn't have specific rules. It's going to be under the county, and it depends on what the county does. The county currently is set to expire at the end of this month, but they will be having a meeting again soon, and will decide whether or not they want to extend it to July. There is probably the high likely chance that they're going to push it to July. They're doing it on a month-to-month basis. And the reason why is what I said earlier is people are just starting to go back to work. So they might not have had a full paycheck or a full whatever that's going to come in for their money, so that they're not going to be able to pay July. But if they're back to work by August 1, they should have what their typical pay is and should be able to pay the rent. Can I file an eviction after June 30th? It depends on what the county does. Do you know of any class action lawsuits against the county? Well, yes. The association, Apartment Association of Greater Los Angeles has brought a claim against the county. I'm sure there are lots that are going to follow. It is based on constitutionality of whether or not these ordinances are a constitutional taking and whether or not they're legal. I am not a constitutional rights specialist. In my opinion, this shouldn't be the way this is handled, but I'm going to have to let the constitutional attorneys make, their arguments and see what happens. All right, so that's all I have with the updates. I know this went pretty quick, so if there are any more questions, I don't have any more in the open question and answer.
There aren't any more right now, Eileen, but if anybody else has any questions, please put them in the Q&A so Eileen can get them before she ends.
And like I said, these are changing rapidly, and being in the courtroom yesterday was really enlightening just to see what this judge has to say. They are set to open. The courts are going to try to get the backlog done. Court trials will be resumed before jury trials. My indication with what I see the tenants attorneys are doing is that there's going to be more requests for jury trials, which will, in my opinion, is they like to extort landlords for more money because they know that the landlords don't want to go through this timely or this lengthy process to get a tenant out, especially if they can get them out by paying 10 grand, get them out next month and get another renter in that's going to pay rent versus paying me $15,000 and waiting till next year to get a tenant out. And I see that there's a question about recording. I'm not sure if this is recorded, but I do give a PDF of this. If you want to email me, you can do so, and then I can turn this into a PDF so that you can have the slides. And also, if you always want to keep up to date, like I said, I recognize quite a handful of names. I do have a VIP list that are for my real estate professionals on my website. If you go there and click on the VIP list and enter your information, I send out mailers once a month. I was sending them out weekly when things were happening pretty rapidly, but I'm not sending them out as much. Next Wednesdays will be this, basically. I have getting them just finished up with hyperlinks to the regulations and where you can find the information. But yes, if you get on that mailing list, the next week's mailing on Wednesday will be an update on all of these rules. I also do other topics related to real estate, LLC formula. My next couple are going to be on LLC formations for holding real estate, buying real estate. So that kind of information is available if you get on my mailing list. My email, I think Nikki has put in a link of where you can get that information. As of August 1st, landlord has to give tenants documents in reference to COVID rights. Not sure of the form. Do you know about that requirement? Yeah, so that's what was discussed. So Santa Monica requires owners to give certain information. They had to do it within a certain amount of time. I think Pasadena has that requirement. The city of LA also has that requirement. The time for that notice has passed, but anytime a landlord gives a notice to terminate, so once the moratorium is lifted and say on August 1st, you want to do a 3-day notice, that 3-day notice has to include the form that is provided on the rent stabilization ordinance page, hicdla.org, I think. They have a fact sheet, and then they have a blank form for the tenant to complete should they need to notify their tenant or their landlord of the inability to pay. Long Beach has specific language that needs to be put in a 3-day notice. So yes, there are forms. The type of form depends on the jurisdiction and where your property is. Any other questions? So my understanding is Nikki just put my email address into the general chat. so
Yes,
you can get
the
that.
email address is in the chat. I just put it there.
Thank you.
Sure.
Any other questions on the substance? No? Like I said, this is changing very rapidly, especially now that we're ending towards the end of the month. Come July 1st, we might have some new information. You can always, like I said, go to my website and get on my mailing list. I also have a Facebook page that I put updates on things that are happening. I get reports from the apartment associations that come through, like they're gonna try to put something through legislation-wise that gives 10 years to tenants to repay this. The article is on my Facebook page. So I try to provide my clients with as much information to stay up to date. If you get on my mailing list and you have if you have a property manager that you would like to get information, I try to send out to them directly certain information, especially when this all started, because they didn't know what was going on. And I do right now for your clients, I am running a COVID-19 special. I'll give property owners, landlords about 30 minutes of time for $75 to explain all this so that they understand their rights. The best way to keep informed, yeah, there are city pages, but the stuff isn't readily available, like you can't find it. What I have been using to stay up to date is the Apartment Association of Greater Los Angeles. I think it's aagla.org. They have all of them listed, but they have a spreadsheet that they update pretty regularly on the summaries of each of the jurisdictions. There was a lawsuit defending landlords that was filed last week. Is that really going anywhere? I'm not familiar with that one. Victoria, if you want to email me, I can look at it, but I just don't know what case that is. Do you work with tenants too? Very rarely. I do tenant work when it's not related to evictions. I do have a couple tenant cases of habitability. The tenant doesn't live there anymore. The landlord didn't refund a security deposit, didn't take care of some habitability issues. My client suffered damage. There's several reasons why I don't represent tenants within the eviction process. Is one, is if you can't afford your rent, you can't afford me, just to be honest. Pay your rent. You're in a contract, your tenant needs to pay the rent. And second, it just creates conflicts because I represent so many property management companies and individuals that there is just that potential of a conflict if a tenant were to call. I do sometimes field them and check for conflict checks, and I'll talk to them, but they usually don't like what I have to say because I think you need to pay your rent. Any other questions? I don't see any other questions, Nikki. All right, well, everybody, thank you so much for joining us today. If you email me, I can send you a PDF of this. And if you go on my mailing list, I send out information pretty regularly. And also on my Facebook page, there are updates that I give whenever they come in. I just kind of put them up there so people can see them. Thanks, everybody.
Thank you. Thanks, everyone. The video will be up on our YouTube page later this week. Thanks, Eileen.
You're welcome.